Okay, you can start now.
Okay, thank you. Hey, everybody. Thank you for being here today and participating in the Mississippi State Board of Medical Licensures Ad Hoc Committee on Hospice Rules and Regulations. My name is Dr. Dan Edney from Vicksburg, and I'll be chairing. I am one of the board members. I'd like to remind everybody that this is a public meeting. If we have any members of the public, we're glad you're here. And just remind our committee members that this is public as you're making your comments. And I would like to, before we get started, just quickly make sure that the committee members know each other. I'm just going to go around, and if you would introduce yourself, your specialty, and your role in hospice work. Dr. Houston, would you start?
Sure. I'm Jerry in Houston, and right at the moment, I'm medical director of Medical Assurance Company in Mississippi. But as most people know, I started hospice ministries over 30 years ago, and I'm still there acting as medical director, taking care of lots of patients at home and in our inpatient facility.
Great, thank you. Dr. Turner?
Yes, good afternoon, everyone. Glad to be a part of this awesome group. I'm an internal medicine physician here in Jackson, Mississippi, and I own my clinic, Turner Care, which I've owned since 2013. And I am the hospice medical director of Specialty Hospice.
And how long have you been working in hospice, Dr. Turner?
And I've been doing hospice since about 2014.
Okay. And thanks for helping us today. Dr. Gentry?
I'm Dr. Dustin Gentry. I live in Louisville, Mississippi. I have a primary care practice here. I specialize in family medicine. And I medical direct for Quality Hospice. Just kind of have a full scope practice here, like a lot of you guys do. Glad to be here. Thank you for the invitation.
Thank you for serving. Dr. Joyner?
My name is Tom Joyner. I'm presently the Chief Medical Officer for Molina, but before that, I was just a family practice doctor that practiced medicine for about 35 years in South Jackson. I was in medical school and early in my career when we talked about hospice but did not have it. So I went from concept to fruition to fully using hospice to the time that I left to go to Molina. So that's me.
And now you pay for hospice.
That's it.
And just so everybody knows, Dr. Joyner is also one of the board members for the Board of Medical Licensure. And again, I'm Dan Edney, internal medicine in Vicksburg, and I've been medical director in Vicksburg for a little over 20 years, since the very beginning when we first got our own place in Vicksburg. And so it's nice to see the wealth of experience and expertise that we have on this committee. This is a committee that was appointed by our board chair to serve in advisory capacity to the Board of Medical Licensure as we try to finish up promulgating the rules and regs for hospice care overall. And first of all, I want to thank you for serving, because you're not serving the Board of Medical Licensure, you're serving the people of Mississippi. And as we work through this together, I just want us all to remember that the focus is on the interest and the safety and the appropriate access to care for Mississippians. My own self-interest, I have to subrogate to that so we appreciate giving this time to us to help us do this important work. Just the scope of the work for today is, it's actually should be fairly small for us. Just as a reminder, the Board of Medical Licensure, typically our plate stays pretty full and we're not going around looking for new things to do. Typically things will come to us through the issue of complaints or questions. And Dr. Joyner and I have been on the board now for about 1.5 years, and the board had been working on hospice issues well before we came on the board. So I know it's been at least 2.5 years of fairly substantial board work on this. And this all came about because of complaints made to the board related to the provision of hospice care around the state. Some of it had to do with inappropriate prescribing. Some of it had to do with inappropriate, really, physician supervision. Some of it had to do with recruitment. Some of it had to do with, just discharging patients back to the community inappropriately without the support that was needed. And some of the complaints really had to do with people that had been placed on substantial controlled substances, and then when they lived too long, were discharged to the community with no one to prescribe. Those complaints came in. So we are a complaint-driven agency, and as Dr. Cleveland and investigative staff are looking at these issues, we really did not have rules and regs in place to allow us to make sure that our licensees were providing appropriate and ethical care in the treatment of hospice patients. As you know, the prescribing regulations for controlled substances exempt hospice from those specific rules and regs, but that doesn't mean that hospice needs to be the Wild West in prescribing. So what the board's intent, and Tom, you can correct me if you disagree, but my understanding, our intent was simply to be able to manage complaints as they come in and hold our licensees accountable to do the right thing, and for the rules and regulations to be parameters for our licensees that do hospice, just such as myself, on how I need to be conducting myself in the practice of hospice medicine from a broad perspective. We don't get into minutia in terms of how you should practice hospice, but there are certain basic standards that the board feels that we need to meet when we're taking care of patients, and certainly when we're prescribing opioids and other controlled substances. So our goal is simply to be able to protect the public from those agencies and possibly physicians who are not doing things the way that you would do them, and be able to hold them accountable for that. But we do not want to impose unnecessary burdens onto our licensees. And a lot of times as we work through issues, we may not realize some of the burdens that may fall into the laps of physicians and other professionals that we license. And so backing up and being thoughtful about this is entirely appropriate. You have before you, an email was sent to you with 2 documents. One is the final rules and regulations that we promulgated and enacted last year. I think it was June, if I remember right. And that was after all the testimony and a lot of board meetings. And I'll be honest with you, there are differences of opinions, even among board members, but coming together to a consensus of what was promulgated last year and enacted. And then you also have a copy of the markout where after the legislative session with the Senate bill dealing with hospice, that the licensure board voluntarily on its own accord chose to withdraw those rules and regs and strike item 4 until we had a chance to clear up any issues of misunderstanding or give us a better understanding of what we need to be doing or how to do it. So I can tell you the intention of the board is to get it right, and to get it right in a way that patients are safe, families have ability to be cared for as well, but not put unnecessary burdens on our docs. So you have before you that language that we can look towards, and we definitely are hearing input from family physicians and some members of the hospice industry, and we want to respect those opinions and listen to them and see what we can do to make this better if at all possible. Please understand, nothing in our rules or regs have ever meant to hinder a physician's ability to care for hospice patients and to do so in an expeditious fashion, including there's nothing meant to impede the prescribing of any appropriate medication at any time at the beginning of an admission. It's not been our intent to increase the cost of care. And so we, by forcing people to the bedside, which is why we need to talk more about this. And definitely that the Mississippi State Board of Medical Licensure is on notice saying that we do respect and appreciate the team concept of hospice care and in no way want to impede the function of hospice teams. So having said all that, there are still some basic tenets to the practice of medicine that the board feels that we need to adhere to. And that hospice in and of itself does not exempt us as physicians from doing those basic tenets. And one of the most sacred is that we, patients that we're treating, that we do evaluate the patient. But we are very open into how that evaluation can go. I think we've shown that in the past we've been open, and we're even more open after testimony at the Senate Public Health Committee and through the COVID crisis. And I'm going to recognize Dr. Gentry in just a second because he made some very thoughtful comments at that hearing and brought up some very important points that I think we do need to address. And I think the licensure board will be open to trying to correct if we can get the right language. But all that is to say that's where we are today. And so now we're asking your opinion on what can we do to wrap this up and get appropriate language in place, and so we can get about doing the business of the board. Also, Dustin, I want you to address the issue of who does the evaluation and prescribing. That's a very, very important issue. So, and I'm gonna let Dustin go first and make any comments that he has, and then we'll open it up to everybody at that point. Dr. Gentry?
I would like to make sure that even though I go first, I could maybe make some more comments along the way as things come up.
Oh yeah, this is just a committee meeting, so everybody can say what they need to say. Let's just don't do it for 3 hours, okay?
No, nobody has that much time. First of all, I'd like to thank you, Dr. Edney. I haven't had the pleasure of meeting Dr. Turner, Joyner, or Dr. Houston, though I have heard of them and always good in a good light. And I appreciate you guys just practicing medicine so well. I'd also like to recognize that I firmly believe everybody here is after the same goal. We all want what's best for the dying patients in Mississippi. And it's a place we love, and it's a bunch of people that we love. And so I certainly think we all have the same goal, and hopefully we can come together and kind of hash this out a little bit so that everybody can be on the same page. And then, on other issues, we could, continue our good work together. I would just like to really, and again, and no offense taken, I would like to address the regulation as a whole, and then focus in on part number 4, which is kind of the main business of the day. When I read the regulation as it was originally written and then clarified by Dr. Cleveland's letter back in February, it seemed to me there were 2 things that came to my mind. One was I was confused, and the clarifying letter didn't help any. And I'll point out the things that were confusing to me as a prescriber in Mississippi, and as a hospice medical director. And the second thing is, and I realize that you guys are a complaint-driven board, and so you've got to have a way to approach physicians that you're having complaints about. But as I read the regulation, it seems to me, just as an outsider reading it, that, you know, it doesn't seem hospice friendly to me personally. And I'm sure that wasn't the intention at all. When one of the issues is it seems to address several problems that I don't really think are problems. But again, I very well may be wrong about those things. To start with, in the very first point, be the second paragraph, it has this several sentences about self-referrals. And, you know, self-referrals to me would be referring to a hospice that you own or you have some type of financial relationship with. And that is already against Stark law and anti-kickback. That's against federal law. So it would seem that if I were self-referring with some type of incentive, then that would be a problem that would be a legal issue. And the medical board could certainly, you know, get in on that as well. And they should, I would say. But the truth is that all of these contracts, they have to be reviewed and they have to follow Stark law and all the anti-kickback statutes. We cannot, none of us can be compensated for any type of referral based system. And, you know, none of us own any hospice companies, you know, so referring to ourselves would really be probably impossible. And but I do understand what you mean is referring to a hospice for which you have a contractual obligation, which I think is a little bit different. I believe that that self-referring is and should be allowed and not scrutinized even in the slightest. And the reason is because I have a responsibility to my patients to recommend the best hospice company or the hospice company for which I believe they will get the best care. And a lot of times that means they'll get the best communication between their team and myself. And I'll bring up at this point later, but one of the biggest problems that this regulation doesn't really address is patient hijacking by the hospice companies. A lot of the hospice companies, you know, if I have a patient, and I'm sure you all understand what I'm talking about, if I have a patient and they are referred to a different hospice company because it's their right to do so, you know, somebody works for them or you know, there's their friend or whatever. Oftentimes, even though I'm their attending physician, that is the absolute last I will ever hear from that patient. And I have to have some very pointed discussions with those hospice teams. And sometimes it's not well received. So there may be a better term, but I call that patient hijacking. When I'm the attending physician and another hospice company gets that patient and I don't, you know what happens, I'm just sent paperwork to sign because I'm the attending on call or on file. All of that is inappropriate, and none of that is addressed in this regulation. I'll read some things from the Minimal Hospice Practices Act or document later, but it doesn't really say it's against the rules to do that, but it's clearly not the way that hospice is meant to work. So the self-referral stuff is really, I don't understand what it's supposed to do, really. And then in part number 2, it says, I don't really have a problem with part number 2, but it says expected death is 6 months or less. And really, I think that should be, instead of saying 6 months, it should be tied to some CMS standard, because we all know the government can change at a whim. CMS could redefine hospice benefit as, you know, terminally ill with a life expectancy of 4 months or 8 months or 9 months. And then you'd have to go back and rechange all this stuff. Part number 3 has no problems. I'm going to skip part 4 just for a minute because that's the main thing. In the first paragraph after verse, you had Sunday school on your mind, Dr. Edney, a while ago. The first paragraph after part number 4, you know, there's this soliciting, you know, an active recruitment. I don't know of anybody that does that, but again, you're a complaint-driven board, so you may very well have been getting, you know, complaints about that. Unsolicited interaction could be taken as a lot of different things. You know, last night I was taking care of a dying patient, and she kind of knew she was dying, but she didn't really know she was dying. She didn't bring up hospice. I did. And so to me, that kind of can be construed as unsolicited by the patient. And so what I would like, you know, I would like to see a verbiage there that says with a patient that is not your own. So it would be against this regulation for me to approach your patients that I don't have a patient relationship with and start talking to them about hospice. And I think we all say that's inappropriate. But with your own patients, I think it would be very appropriate to bring that up. And then, you know, in the next to last sentence, I don't have a problem with that at all. I do think it's redundant and unnecessary because lying is already against the AMA Code of Ethics. But because everything is being done virtually these days, instead of saying meetings when they did not attend the meetings, it should probably say participate, because most of my meetings are occurring virtually, just like this one right now. And there's nothing to quote attend unless you say it's a virtual attendance. Now, to go back to the point really about the self-referral, that actually doesn't really have a lot to do with establishing a proper physician-patient relationship. That just seems to me like it's thrown in there in this little paragraph because it was wanted to be talked about, but it really doesn't have anything to do with what that leading sentence says these 4 things are going to be about. It seems out of place is what I'm saying. Now, really speaking about point number 4, I have several issues with that, and I talked about those in the committee meeting. It presents a lot of challenges for a clinician in a small town when these patients can be, you know, in several different parts of the county, and when we're already stretched so thin, trying to do the right thing for so many patients. You know, I know we're all busy, but I can work in the ER, the hospital, Jerry psych, nursing home. I can make some home visits and still have, you know, I've got obligations to my own family at home with my children and my wife. And so because we are so stretched for primary care physicians, I think that it places some undue burden on the small town docs. And that's what the MAFP hospice medical directors are taking issue with. And we're taking issue with that for good reason. We talk about standard of care, and to me, that's a sacred term. It's hard to define, but it's closely tied with the term best practice, I think. And when we look around the country about how this issue of examining before we prescribe any medicine really is dealt with, there are exemptions, the same kind of exemptions that I'm asking for and the MAFP hospice medical directors are asking for today in 36 different states. And I have that in front of me. I will not bore you with it if you'll just give me the latitude to make that claim. I have links to all of those different documents. And of course, everybody's got their...
Why don't you send that in to staff for us?
We'll get it to you.
We have the same information you have, but go ahead and send it in.
Okay, thank you. And I would fully expect you and you know, to look at that. We have links to all of those different documents that, you know, per state. And I'm not going to bore you by reading through these, but I have read through all of those. And so other states, actually more than half of the states in our country, have made an exemption for hospice because they realize that this is a special type of care. And they know that it's important for hospice medical directors to fill that gap when the attendings can't do it, don't feel qualified to do it, or are unwilling to do it. Now, I will take this time. This is a really good time, and I appreciate y'all giving me the few minutes to explain all of this. In the minimum standards, subchapters 12 and 13, it defines what the responsibilities of the hospice medical director are. And I'm just going to kind of read a couple things. Collaboration with the individual's attending physician. So that means the attending physician should be the main physician in a hospice patient's life. And then in 18, it says serve as consultant with the attending physician. And letter B under number 2 there says serve as the attending physician if designated by the patient and family unit. Those are on pages 21 and 34 of that minimum standards document. What that means is the attending physician, not the hospice medical director, should be the main prescriber, should be the main doctor in that patient's life. And that's my philosophy. That's the philosophy of of the hospice company that I work with.
That's ours too.
Too many, way too many hospice companies, especially the corporate ones, and I hate to pick on any of those guys, but they have a what's easiest mentality, and so they're going to send their nurses out, and those nurses are going to pop in and even, you know, send a text to their medical director or call them or whatever and get some orders, and then completely circumvent the consultation and the team-based care with the attending physician. And if I had to criticize hospice, that would be my criticism, because I am the physician that has been cut out many times. And to be honest, being cut out is what drives the self-referral. Now, my patients realize that they do have options, and I tell them, and especially in the hospital, I just walk out and let the case manager tell them about the hospice companies after they've decided to go on hospice. But that's neither here nor there. So to the point of standard of care, more than half the states is my point. They all have exemptions for the physical exam requirement for prescribing to hospice patients. And we'll get you that document.
Yeah, and there's no requirement for a physical examination.
Sir?
There is no requirement in these regulations for a physical examination.
Okay. I'll
It's
get
evaluation.
right. Okay. We'll I may have a follow-up question about that in a minute, sir.
Okay. Let's get on.
The second thing is scope of practice. When the hospice regulations originally came out, what all of the hospice companies around were saying were they were going to employ nurse practitioners, you know, and these days you can get a nurse practitioner certification with 2 years online stuff and a little shadowing. And I feel like I'm more trained to treat my dying patients' needs than those patients are. It undermines the physician-led team when the nurse practitioners, per Dr. Cleveland's letter and this regulation, because they have the ability to go and actually see the patient or do whatever, you know, this regulation says, for them to be prescribing all these medicines and have less training, and he who is prescribing is the lead of the team. That is really what it boils down to. So the scope of practice thing is a really big concern of mine. And then the last thing there's other ways to fix the problem. I've heard Dr. Edney and several others mention that there's so many medications prescribed to these patients. There's other ways to fix that problem. I don't feel like that's a problem that is with my prescribing habits, but if there are other physicians that are doing that inappropriately, there can always be limits placed on how long you can prescribe these medicines. Give them 2 weeks at a time, or 10 days, or heck, even a week at a time. And that'll limit how many these people are getting that are superfluous once they pass away. So I hope that was all well received. I know I spoke a little bit long, but
thank you. Thank you, Dustin, so much. No, I was taking notes. Just going back to the self-referral issue, and maybe we do need to wordsmith it some, but that was absolutely to protect doctors like you from exactly what you said. Because if you see, it requires, one complaint we were having was that primary care doctors were having patients admitted to hospice and they knew nothing about it until they came in for their 6-month checkup and found out they were on hospice. And so that item requires primary care docs to be informed. And the self-referral we're talking about is, it has to do with contractual obligation, which I have and you have. Right. And it's absolutely appropriate for me to initiate a hospice conversation. That's the practice of medicine. And it's appropriate for me, to take care of patients of mine that choose my hospice agency. But if they do that, we're providing that second layer to protect you from your patients being snatched. So, the self-referral was in no way meant to be derogatory towards doctors taking care of their own patients, but really agencies snatching patients, just as you were describing. The unsolicited referral had nothing to do with talking to your patients and initiating a conversation. That's the same as initiating a conversation about needing surgery. That's the practice of medicine. Absolutely. One thing that, in terms of making it easier to do the evaluation, the original item 4 said, we gave all the options that would satisfy this regulation, which include, if you want to make house calls, and believe it or not, I know hospice directors that want to go to the bedside at home. They want to do that. Absolutely, that's good. If there's a mid-level going, that mid-level has to be part of your team and under your protocol, or they can't practice. So if that mid-level is going to the bedside, they're doing it for you and under your direction and under, and that, and you've got a collaborative relationship or a supervisory relationship if it's a PA. So hospice agencies can't just hire them to replace you. And, and then we wanted to allow telemedicine. Well, that was all before COVID. And as you well pointed out, COVID has laid bare the difficulties in doing full level telemedicine in rural Mississippi. And Dustin, remember, I'm a primary care doc in small town Mississippi too, wear a lot of hats. So I know exactly what you're talking about. And I know Dr. Turner, he's in Jackson, but he wears lots of hats too. But that now that we know these problems, the conversations that we've been having is that does need to be fixed to where, connect. What we're wanting is for doctors that are treating patients, that are writing control sets for patients, to connect with the patient or the patient's family if the patient's unresponsive, and be part of that care plan and not just sign off on what folks that don't have prescribing authority are recommending, but to be part of the care plan. We are supposed to be leading the team. And many times we're just being told so-and-so needs more fentanyl, and so it's, the evaluation is not a history and physical. It is connecting in whatever way you think's appropriate. We're allowing discretion of the prescribing physician on how to do that. Now, the term telemedicine we have to work with just because there are areas that can't do it, and that's very well received. Also, the clarification letter that you're talking about, I think it's on the table for us to talk about, you know, respecting the hospice team approach. And if I do send my mid-level to the bedside to do the evaluation, then I'm responsible for reviewing that and signing off on it, and then allowing prescriptive authority for all of us on the team. You're exactly right. The attending physician, if he or she wants to stay on the team, absolutely should stay in that role. And as a hospice director, I never want to take that role away from a primary care physician who wants to attend. As you know, there are a lot who opt out and don't want to attend, and then we take over. When that happens, if I've never seen the patient, nobody on my team's ever seen the patient, I need to reach out and evaluate that patient myself. Not before I prescribe. I can prescribe immediately, but sometime within 30 days, get that done. And if that means doing a FaceTime or picking up the telephone, that's not a burden. That's the same as doing an office visit, and we add office visits on the day, all day, every day. So that's the perspective of the board. What we want is to get things that are true burden fixed and language corrected. So let me open it up to the other committee members for comments, thoughts, concerns, point us in the right direction.
Sort of have a question, because I know the last time I attended some of the hearings, the number 4 was there, that we needed to do face-to-face visits, so some sort of visit to establish the doctor-patient relationship so that we could prescribe our opioids. Then it went to the legislature and y'all withdrew that part. Where are we now with that number?
Well, that's what this committee is to do. We are to give a recommendation to the board about that.
What did the legislature decide?
The legislature, actually, the Senate bill didn't change anything. Okay. We've never required a face-to-face. Okay. So, I mean, we could have left it in place and not changed a thing. Well, we want to get it right. What has changed is COVID. Yeah. And now, as you know, I mean, CMS is allowing a phone call to establish patient care.
People don't even have to be seen anymore by the nurse. Yeah.
So I think I can't speak for the board, but I think it's totally reasonable to allow physicians to do the quote evaluation however they need to do it.
Let me just tell you what we've been doing. When this number 4 first came out, we said, okay, I'm a rule follower. We're going to do what we need to do, but we always put patient care first. We try to let the attendings take care of the patients. We encourage that because they know the patient. But when number 4 came out, we set up something called an established care visit. And within that first 4 weeks, I would FaceTime, for lack of a better word, or do a telemedicine visit with these new patients. It's good. Now I've got a name and a face. I know who that patient is. And the patient knows who I am. And it's a good thing. Even if this number 4 goes away, we're going to still do that. We can't charge for it, but it's doing better patient care. And we're going to continue to do that. I sort of fought it at first, but now that we've looked at it, being able to do it when the nurse is out there already doing a visit, they take 5 minutes of my time. I think it's a good thing to do. We're also making sure that primary care physicians get letters. The nurses who evaluate the patients have to get that blank filled out. If there's nothing there, they say none, but we always send a letter to the primary care physician so that they know that they've been admitted to hospice. And those are just things they're better. Take care of patients better that way. And so that's sort of my take on those 2 things.
Jerry, what's your opinion about, of course, if you do the established care visit that yourself, it doesn't matter, but say if you delegated that to a mid-level and you delegated
we are one of those sort of small organizations, and we have one nurse practitioner who basically works in the inpatient unit, does more administrative stuff. And he may do one when I'm not available, but basically I'm doing it. I think it's sort of like the real face-to-face visits. The mid-level does it. He or she has to coordinate with me and talk with me and discuss it. And that's got to be part of it.
Yeah.
It's like when you do a face-to-face visit for research. It would have to be along those same lines.
And doing that, do you have heartburn allowing prescriptive authority within your team based on a mid-levels?
Not
established
if we've had that conversation, and I'm going to review the records of every patient that I see. I'm going to know who these people are. I mean, and I knew these patients even before I started doing this face-to-face visit because I review the records. I make sure they're hospice appropriate, and I make sure they need those medications. And for somebody who's at risk, we may deliver medicines 3 times a week. I mean, we're going to work with whatever we need to do to make sure those patients are taken care of. And the families are not diverting the medication. And if mid-levels are handled the right way, I think it's an okay thing.
Okay, thank you so much. Dustin, one thing I want to commend you on, the reason that you don't think these things are a problem is because you're not doing these things. Right? You're doing what you're supposed to be doing.
Yeah,
You know,
exactly.
so our intention would be for the guidelines not to affect what you do very much, but it would affect those who are intentionally trying to get around things and allow us an opportunity to hold them accountable.
But we also know the people who don't follow the rules are never going to follow the rules.
They're never going to, you're right.
It's
Absolutely
like the
right.
face-to-face visits that were developed to keep people from being referred inappropriately and to keep from being recertified inappropriately. Those people are still getting around the rules, even if they're doing face-to-face visits.
The good thing with a regulation from the licensure board is if there's a complaint and the investigation bears fruit, now there's an avenue of discipline.
We're looking into this for sure.
That's exactly the point. And coming from somebody who has done investigations and had to testify in these situations and recoup millions of dollars, we know that there's much more fraud out there than we really know about. And so that's why some of these regulations come about. And so as I look at these regulations, I don't see that they're that prohibitive. And they need tweaking. You're absolutely right. But I think we need to tweak them where we can make sure that the docs are able to take care of their patients appropriately.
Dr. Houston, may I ask you a question?
Go ahead, Dustin.
Yes.
Okay. So the established care visits that you have, you know, and back when I sent emails to state medical and I sent emails to the medical board and to MAFP. I mean, there was all kinds of doctors. You know, we're trying to figure this thing out and really trying to do what we're doing today and make it more workable. But how are you doing? Obviously, you're not bringing in the bedbound patients into your office. You know,
No, it's all telemedicine.
Okay.
When a nurse is at the home with an iPad and a Teams app that we have to use, one called Teams, she will call me, you know, ahead of time, and we'll say, yes, I can do my visit, and she'll just set it up while she's at the patient's home.
Now, in some of the correspondence I've seen, and I'm reading an email from my mind, but I can't remember who wrote it, and I apologize for it. But we were asking for clarification, and someone said, yes, an iPad or an iPhone or a FaceTime visit is okay. And I don't know if they were speaking because there's a pandemic or what, but I feel certain that at some point this FaceTime stuff we're doing is not going to be smiled upon by the HIPAA people. I mean,
well, I think if you have something that's compliant, and we were doing this, this was before COVID, that you were allowed to do a face-to-face visit by telehealth, if I remember correctly. You can't do it for Medicare, but you could do it for the licensure board to establish that relationship.
Right.
Yeah.
Right. But, you know, but what I'm saying is we have to have HIPAA compliant technology, you know, and then of course there is some issues, but I think Dr. Edney has said that you can fall back on a telephone call if the internet service like we have out here is spotty.
I had one last week that we couldn't get any service except by the telephone, and we tried. I considered that was actually a
Absolutely.
face-to-face visit, but that's all I could do.
Yeah, and I think we should put that in that verbiage in the regulation. You know, not just telemedicine, but the highest level available, including audio only, if nothing else.
Yeah.
So
we even changed our consent form for hospice that you would put a telemedicine clause in there, telehealth, that some of your care may be by telehealth, just so you can make that would be legal. That's just what's easy to do.
Right. So I have another comment. The way that this is worded, I don't think really fits your Dr. Edney and the boards in number 4. I don't think it really fits your intention for in another way as well, because you said that you don't require a physical examination. But as I understand evaluation, I really think historically that has meant a history and physical examination. Detailed history and an exam.
We intentionally took the history and physical verbiage out and put evaluation in place. You can't do a physical by telemedicine.
Right.
No.
Unless you have extremely high capabilities. So, for me, allowing telemedicine and saying evaluation, basically it's connecting with the patient. However, and we're giving you discretion to do that. We just need to make the terms clear so that you know that you have that discretion to do the established care visit, like Jerry's saying, however you want to do it.
I think it should be clear that a physical exam is not required, and
if we're putting audio only as an option, Dustin, that's telling you that physical exam is not required.
I never had the impression that a physical exam was required, but by this.
Yeah.
Dr. Houston, are those mid-levels on your collaborative agreement?
We have one, but yes.
Okay. Would the board be opposed to there not being a collaborative agreement? Because that has been a point of contention among many of the medical directors. There's nurse practitioners on the team that see the patient, but some of the medical directors don't want to have the liability of having a collaborative agreement with that nurse practitioner.
I'm not sure who else he would have an agreement with. But.
Yeah, that's they can't practice without it.
We're not full-time hospice doctors, and so we have. I work for a hospital, and there's 8 nurse practitioners, or 8 or 9 nurse practitioners here in the system, and I'm primary or secondary with all of those. And there is a nurse practitioner on the IDT team with the home hospice company that I work with, she's on that team, and she has a collaborative agreement with, I think, the main medical director for the hospice. But the hospice company has several medical directors, to cover all of the patients appropriately.
Well, I'm the chief medical director. We have several hospice physicians, but we only have one nurse practitioner, and I'm the main person, the collaborator. The other ones are secondary, but I don't know how we would get around that unless I'm missing something here, because he works full-time for hospice.
Yeah, Dustin, if you have a mid-level on your IDT that you're running, they have to collaborate with you on that team.
I'm sorry, sir. I didn't hear what you said.
What did you say, Jerry?
I think if you have a nurse practitioner who's seeing your patients and doing your face-to-face visits and things like that, they have to be employed by your hospice, as I understand. Is that not correct?
That's right.
Yeah.
But that doesn't tie them to me. They're just on the team.
Well, but I don't know who his collaborator would be, because it'd have to be somebody, one of the hospice physicians. We would all have the same situation.
Right.
But I don't see any way for I don't see any way for there to be sharing or collaborating a prescriptive authority if your mid-level is not collaborating with you. That makes no sense to me why they would put a mid-level on your IDT and not have them collaborating with you as the hospice director.
What I was under the impression that the medical board wanted was for a person with prescriptive authority on the IDT team or on the IDG team to examine the patient, or excuse me, evaluate the patient. And then as a part of team-based care, like is listed at the top, communicate with the attending physician who should be writing all these prescriptions, to be honest.
All right.
Or
if it's the attending physician, it's not a problem.
well, that's true.
You have to have an attending, you don't have to do that.
You don't have to do that as attending, but say as the hospice director who's going to assume prescriptive authority, yes, then go ahead with that scenario that you're the medical director, you've never seen the patient, there's no other attending going to be involved, and you choose to have a mid-level go.
Well, now there is an attending. There always has to be an attending of record. There's 2 physicians on every patient, an attending and a hospice.
Dustin, we all understand that. But what I mean by attending, I'm talking about a referring primary who wants to stay attending. If you're assuming attending and you've never seen the patient, there needs to be an evaluation. Now, if a mid-level goes, Dustin, that should be your call. All you have to do is pick up the phone and call the patient or the patient family yourself and do it yourself. You don't have to send a mid-level. That's your choice. You are the medical director. You should be driving the bus.
Yeah, we do drive the bus. The patient, I'm trying to figure out what the intention of the medical board is, though. The collaborative agreement is a point that probably needs to be worked out. So we're collaborating as a team, okay? But with the Board of Medical Licensure, it's not an official collaboration. You see what I mean?
It needs to be. You can't collaborate with a mid-level. You can't collaborate with a nurse practitioner in any way without a collaborative agreement. You can't give her instructions to go do something and she do it under your license. If
She's
you
not
don't have a
doing
collaborative agreement.
I don't think she would be doing anything under my license. She is evaluating the patient and communicating with. This is the way it's been done for a long time, Dr. Edney.
Dustin, I've been doing this over 20 years. I know how it's been done.
Well, I know that's what I'm saying is the hospice medical directors really don't want to change in the way that it's been done. I mean,
the collaborative agreement is not a change. You need to go read the rules and regs related to collaborative agreements, and you've got to follow those. That's not new.
Right. I'm not breaking any of those rules.
I don't think you are. So if you have a nurse practitioner that you have a collaborative agreement with and you want to send he or her to the bedside and do what Dr. Houston's saying, that's totally fine. Or you can do a FaceTime or you can pick up the phone and do it yourself. That's at your discretion.
The way I look at it, the rules and regulations as we're trying to write them intends for the hospice directors, the attending physicians, and the nurse practitioners to be able to do this unencumbered. And the way we got it written, I think is pretty close to that. I think it is that. So what specifically would be prevented?
Here's the verbiage that, I didn't communicate that last point very well, and I do apologize for that. I'm going to be thinking about the right way to say what I was trying to say. In the part 4, as it was revised, the temporary filing, so to speak, the last line of that number 4, what what we would like to see is the phrase "an in-person" replaced with just the letter A. That's what we would like to have in that number 4.
And I thought that was covered by allowing telemedicine, audiology and such.
So are y'all opposed to doing anything, or, I mean, y'all opposed to doing telemedicine, FaceTime, or audio only?
I don't think we would be opposed to audio only, but the audio only, Dr. Edney, would be hard to argue with. Okay, I couldn't make an argument against audio only. If you're wanting us to pick up the phone call and talk to the patient's family before we prescribe medicines,
No, stop.
go ahead.
Please stop saying that. We said it every way we can possibly say it. You don't have to do this before you prescribe. You've got 30 days.
Right.
30 days to do it. 30 days to pick up the phone.
I'm sorry for using the word before.
Okay.
I'm sorry.
That's a sticking point with us, Dustin.
All right, that's fine. I won't make that mistake again. In clear conscience, I don't think that I could make an argument, and you and I have talked about this before. I don't think I could make an argument on my behalf or anybody else's behalf about the requirement to pick up a phone and talk to a patient and their family that we don't know. I can't make that argument. What we want to do is to make sure that we can still see 25, 30 patients a day round in the hospital, have family time, and not have to really deal with collaborating or forced collaboration with anybody that we're not, that's not working for us or prescribing for us or anything like that. The nurse practitioners that work for the hospice companies, they don't prescribe medicines, not the ones that I work with or the one that I work with. They don't. So that really kind of needs to be clarified on that other conversation. That lady, she's not prescribing under my name or for my name or to my patients. All prescriptions come from physicians. And that's the way we want to keep it. And the physician that knows the patient best is the one that should be prescribing. And I think we would all agree on that. But I can't make an argument that we shouldn't be required to pick up a phone and talk to the patient or the family. So if the regulation can say no more than that, basically, and be bare bones and lots of latitude in favor of the physician who's trying to do the right thing for his dying patients, I think I can make a phone call in 30 days, and I think my colleagues can too. But this whole thing about having to, have a collaborative agreement in place with nurse practitioners that don't really work for us, and having to go there after hours and to the bedside, which I do. I go to the bedside absolutely when it's needed. I don't care where they live. But those are judgment calls on my part.
Your discretion.
I've been at 2 a.m. putting peg tubes back in place that fall out. That's things that we all do because it's the right thing to do. But anyway, I hope I made myself clear on that.
So Dustin, let me clarify this. As a board member, I would not support a mid-level on the IDG doing the evaluation and then sharing prescriptive authority with me. That's not on my protocol, or I don't have a protocol with. That's collaboration without a protocol. What we're saying is we're trying to give physicians whatever latitude and discretion to do this established care evaluation, like Dr. Houston said, at your discretion at any of these levels, whether you do it, whether your mid-level does it, not a mid-level, but your mid-level does it, that you're going to sign off on and then work together with going forward, or you do a telemedicine in whatever way you need to do it based on where you are in Mississippi and how you choose to do it. I don't know what else we can do. But what I'm hearing is a problem that we've not discussed before, and that's mid-levels being on an IDG without collaborative agreements.
Well, and I can see that that's a problem if the mid-level is prescribing for the physician or the medical director, if the mid-level is practicing medicine for the hospice medical director.
Right.
Now, every mid-level has to have a collaborative agreement with somebody. And take, for instance, a hospice company that I work for, the mid-level has a collaborative agreement with their, main hospice medical director, kind of like Dr. Houston is for her company. But the rest of us, I don't necessarily want to, because this mid-level also does, clinic practice. I don't want to be on her collaborative agreement when all I'm doing is just sharing an IDT meeting with her, and she is part of the team. She's a valued part of the team. She produces documents that are important, but she doesn't practice medicine for me.
But are you basing, and Justin, we're coming to you, buddy, hang in there, are you basing your prescribing judgments on her, based on her evaluation?
No.
Okay. Dr. Turner.
My prescribing.
Who's doing your face-to-face visits for Medicare research? Are you doing those or the nurse practitioner?
Not on the homebound patients, I'm not. If they're well enough to come into the office, they come into the office.
They come to, you don't go to their home to see them? What about the ones who can't come?
Well, the ones that can't come, the nurse practitioner is doing that part.
Is that nurse practitioner that you're collaborating with, or a hospice nurse practitioner?
It's not my nurse practitioner.
Okay. So do you talk with her after she sees the patient?
We may need to look at that rule. I may actually be inadvertently not following that rule.
Yeah. And don't sweat it. We're not coming down on you. It's just you've shown light on something that I hadn't thought about before, and I appreciate that.
Well, I want to go back before you go to Dr. Turner. I want to go back to Dr. Houston. The reason to something that you said, not actually to you, but I am with Dr. Houston. When you guys make rules, I'm a rule follower. So, I love what I do. You guys control my ability to do that. And I have nothing but respect for the Board of Medical Licensure in Mississippi. And if I'm breaking a rule, and to be honest, I probably am breaking a couple rules and I don't realize it, but I am never doing that intentionally. And so we'll be looking at that.
Okay. Dr. Turner, thank you for being patient.
Actually, it's one of those times where I don't have a lot to say. I can echo what Dr. Houston, Dr. Joyner, what you, Dr. Edney, have eloquently stated so far. Dr. Gentry, thanks for all you're doing. It sounds like you wearing many hats up there, and definitely trying to do things the right way. I did have a question for you. What would be the reason you would be against having your mid-level having a collaborative agreement? Like, what are the cons? What are the disadvantages? Why wouldn't you want to have them a part of your team, which technically they are? I just want to hear from you why you wouldn't want to have a collaborative agreement with them.
Well, it would really need to be, I'm not opposed to the idea of it, Justin, but it would need to be understood. I just don't want to be responsible for the stuff she's doing that's not on my patients with hospice, because she does do, other things. She's got a clinic practice in an adjacent town, and I just don't want to be on the hook for any of that kind of stuff.
And you would not. You're only responsible for how you collaborate with them, with your patients.
Yep.
Yeah, and that's what I was going to say. Not trying to get into a lot of legal stuff, but I think your liability would only be the relationship that you have with her as relates to your patients. And I think you was asked if something that he or she did influence your decision making. So you're telling me that nothing that they do or document influence any decisions that you make?
Very little. I have a red line or a hotline with all my nurses. I know them by name. I've almost memorized their phone numbers. We are in constant contact about my patients. I'm really hawkish about how they're doing and how they're doing at home and all that kind of stuff.
Good. And Dr. Gentry, the thing that's very important, the last thing we would want to happen is for you to stop doing hospice. Okay. So we want to get this right so that we're taking good care of the patients, that we have good accountability for those who are not rule followers, and let all of us do what our training experience lead us to do. We're a little over an hour. I want to be respectful of your time. Do y'all, I think we're very close. Do you think we need to stop here and schedule another visit and everybody work on language to send in, or do you want to push ahead? Dr. Houston, I know that you had tight time constraints today.
Yeah, I've got to leave in just a minute or two. Yeah.
Why don't we call a timeout and then schedule a meeting in the future? In the meantime, we can all think about what language we're going to come up with.
Would it be okay with everybody maybe for me to work with staff to generate proposed language to send out?
Yes.
And get, I don't know, Francis, is it legit to get comments back and forth or no outside of a formal meeting? Is that okay?
You mean like right now?
No, ma'am, like if we propose language and if we propose language, are we allowed to get comments in between the meeting, or do we have to wait till the meeting?
No, if you're looking to post anything, you would want that to be approved by the board first.
No, I'm just internal.
Oh, so internal. Just send it to the office and we'll have staff work it for you, and you just review it until it's in its final form.
Okay, thank you. Y'all, thank you so much for your time. I really, really appreciate it, Dustin. I think we can get there. The reason you're on this committee is you're speaking for a lot of physicians that we need to listen to. So let's do what we need to do to get this right.
Yeah. Dr. Edney, can I interject one thing? This is Hope Ladner. I'm the lobbyist with the board. I just want to point out the one question that we get over and over at the legislature that we need to be able to clearly answer. If it's 2:00 in the morning, somebody just gets admitted to hospice, their attending physician is not around, nowhere to be found. That patient is in pain. Somebody needs to write a script. How do we make sure that doctor doesn't feel threatened or feel like they're going to get in trouble for writing an opioid in that scenario? And that truly is part of the question that needs to be clear.
We will continue to make it abundantly clear, just like we did on the revision, that there is no issue. So the last statement: nothing in this section shall preclude a hospice physician from fulfilling their duty to provide physician services as needed to hospice patients, and they can do so immediately. We will make that abundantly clear. I think I'm going to put it on a billboard between here and Jackson.
That'd be great.
And nobody will step in the way of a legitimate physician legitimately taking care of his legitimate patient.
That's right.
Exactly.
Yes, we will never do that. We're on the outside watching and waiting for complaints and dealing with complaints as they come. No one's going to complain because you wrote a prescription to take good care of a patient when they were in crisis.
Yep.
Again, thank y'all. I will coordinate a meeting and I'll see what works for y'all, and we'll get language together and get it sent out to you. Thank you so much, y'all.
Thank you.
Nice meeting y'all.
Thanks for your leadership, Dr. Edmond.
Thanks, buddy. Thanks for serving again.
See you later, Justin.
All right, Dustin.